This is the climate necessity defense. Where are we and where do we go from here? We use that title because even if you follow this defense closely, it's hard to figure out sort of what's been happening and what that means, like whether it's a good thing or a bad thing. There's been a lot of mixed signals. So we're going to try to interpret that for you. I'll be moderating as well as on the panel. And we'll try to reserve about 5 minutes at the end for questions, although again, we're getting started a bit late. So I'll introduce the panelists now. Please note that Tim DeChristopher, whose name is on the program, was not able to make it, and instead we'll have Marla, who's with the same organization as him, Climate Disobedience Center. So I'm Alice Cherry. I'm one of the co-founders and the staff attorney at Climate Defense Project, which is a small legal nonprofit that got going in 2016 when I and two friends graduated from law school and decided we needed to start something new to support climate activists. Emily Johnston is one of the valve turners with Shut It Down. You may have heard of this action. It happened in 2016. She and about 4 other people turned off all tar sands oil coming into the US in 4 states. And Emily also co-founded the Seattle chapter of 350.org and is a writer and activist. Professor Lance Long teaches at Stetson University College of Law, where his scholarship focuses in part on the effectiveness of environmental advocacy. His most recent article, which he wrote with actually another CDP co-founder, Ted Hamilton, just came out in the Stanford Environmental Law Journal and is called The Climate Necessity Defense, Proof and Judicial Error in Climate Protest Cases. And finally, Marla, who you can't see right now, but is with us, is a co-founder of the Climate Disobedience Center. She is a social justice organizer who wears many different hats as a campaigner, trainer, and pastor. She helped launch Climate Summer and served as its director and is one of the co-founders of the Better Future Project as well as 350 Massachusetts. She supported and participated in a number of civil disobedience actions, including the lobster boat blockade and the Resist the Pipeline campaign in West Roxbury. So those are our panelists. I think we'll start, Lance will give us a short introduction to the climate necessity defense just so we're all on the same page. And then after that, we will jump into our discussion about what's been going on with it lately and how to interpret that and what the future might hold. So take it away, Lance.
Thanks, Alice. Okay, I don't need a microphone because I talk too loud anyway. First of all, I want to say I'm here with 6 of my students from Florida, which is where Stetson is located. I used to be a visiting professor here at the University of Oregon, and my 6 students right there are all budding young climate change attorneys and activists here. And of course, there's a difference between me and most of the people in this room and all of the people here, the rest of the people on the panel. And the difference is they are the doers. These are the people actually putting their neck on the line and defending those people who put their neck on the line. I am just kind of like the chronicler, you know. I'm always there at an action until, you know, they're getting ready to arrest people, and then I'm like, see you guys, you know. I've never been arrested. I've never been locked up. I will do that when I retire, by the way. When we were all at Flood Wall Street, I was there sitting with everyone until the police showed up. You know? And I got to do some interviews tomorrow. I'm out of here. I know Leonard was there. Were you there, Emily, at Flood Wall Street? Okay. And you got arrested with everyone, didn't you? Oh, you left too? Not that time. You've been arrested too many times anyway. Anyway, so what I'm going to talk about as the chronicler, I'm going to talk a little bit about the history of the necessity defense and it's basically parameters, the doctrine of the necessity defense, as it were. And then just a little bit, I'm going to talk about the history of the climate change necessity defense. And I would encourage those of you on the panel and in the audience who know of these specific events we're going to talk about to jump right in because I want to hear it from the people who are actually doing some of this stuff. One of the things I wanted to do is kind of get a sense from everyone here. Who knows what the necessity defense is? Raise your hand by raise of hand. okay, most of you understand the necessity defense, and most of you probably understand. We'll go through it briefly for those of you who are maybe just kind of forgot some of the elements or something. But the necessity defense posits that between a choice of two evils, the law will allow you to choose the lesser of those two evils. Sometimes an actor is put in the situation that they have to choose between two imminent harms. And you can choose the harm that is less harmful even if it breaks the law. In the words of some famous jurists, this particular one being the judge in Renninger v. Foster in 1550, which is the first perhaps recorded necessity defense case. Yeah, you're breaking the words of the law, but you're not breaking the law. And that's the essence of the necessity defense. It started in 1550. A British merchant ship was sailing the high seas with its cargo, and a storm came up, a particularly egregious bad storm. And they started throwing cargo overboard, which was illegal at the time. Who would think, though? Anyway, they were charged with destruction of property and acquitted based on the necessity defense. It was first articulated there that they had a right to choose to destroy some property rather than lose all the property on the ship, their lives, and the ship itself. They chose the lesser harm, and it was okay. Initially, back in the early common law, it was the necessity defense was limited to cases where you had natural disasters, and you had to act to take one choice in a natural disaster to avoid a greater harm. Since then, and then we have what's called the duress defense. We know about that, when a human actor forces you to do something, maybe to break the law, and you claim, I did it under duress. That distinction is not as important for the necessity defense today. You could have the necessity defense based either on man-made causes or natural causes. In the 20th and 21st century, it's been employed in a lot of different cases. As you would expect, DUIs, it's a defense used for DUI. A person will be drinking at home. Someone will get injured. They need to rush them to the emergency room, and they're charged with driving under the influence. Well, yes, I did break the law, but it was to save the life of someone. Prison escape cases is another ripe field for necessity defense, where a riot will be going on, and prisoners will jump the fence and escape. And it's okay, as long as they go and turn themselves immediately back in. That seems to not happen very often in the claimed necessity defense cases. But before I get into how this works kind of with some really good cases, let's just go back and talk about what you have to have for a necessity defense. And this is really important for climate change necessity defense, because when you understand when I talk through the four elements, you'll just think in your mind how that would work with a climate change activist, someone who has broken the law, maybe blocked a train, maybe trespassed, I don't know, maybe cut a chain on a valve, a pipeline valve, taking tar sands oil from Canada to the U.S. and shutting down the valve. How these elements would square up with those kind of acts. Okay, and I even toyed with the thought of let's let audience participate, but I'm not going to do that. I'm not going to do a full-on law school class here, even though I am the chronicler, the professor here. But what I do want to talk about is there are four basic elements. The first element we've already talked about. It's the essence of the necessity defense, and that is, you have to choose between two harms. You have a choice between two harms. And they can't just be any type of generic harms. The harms have to be imminent. You have to be faced with imminent peril. So start thinking about this when you think about doing climate change activism. those are the first two elements. The third element is the actor had to reasonably expect a direct causal relationship between the actor's acts and the harm to be averted. In other words, the actor has to have a reasonable belief that his or her actions would have a direct effect on the harm they're seeking to avoid, the greater harm they're avoiding. And lastly, there has to be no legal alternatives available. Okay, so think about those four elements and how those will square with climate change activism. Okay, so as the 20th and 21st centuries rolled on and rolled through, climate change was used for some really helpful type of civil disobedience and other types of civil activism type cases. It was used first in war protests. It's been, many trespassing and other type cases protesting wars, sit-ins throughout the decades have used the necessity defense. Yes, we are blocking access to a government building. It's an egregious harm. Can you imagine people trying to enter a government building and not being able to enter it? I mean, the harm is, it's enormous. And the Vietnam War, or the World War II, yeah, they had some harm, but certainly maybe not as bad as not being able to enter into a government building. Nevertheless, that's how it was used, and sometimes successfully. Other areas have been, of course, as we're all aware of, the civil rights and activist disobedience to get civil rights laws passed. The proliferation of nuclear arms, that was another area where the necessity defense was used when activists would try to block or prevent the manufacture, transportation, distribution, and even the use of nuclear arms. Finally, illegal activity by the government. For example, when the government maybe is engaging in illegal CIA activity in Central or South America. Necessity defense was used for protesters who shut down government buildings and claimed that the government was acting illegally. Okay, so that's just kind of the background of some of the areas. Anything you wanted to add, Alice, or? Okay, good. So let's now switch to why we're here, the main event, which are the climate necessity defense cases. And I'm just going to go through a brief chronology, and then Alice and Emily and Marlow are going to jump into the specifics of these cases. Believe it or not, this is a significant milestone. This year is the first time we have met here in PIELC, and it marks it's basically the 10th anniversary of U.S. climate necessity defense cases. The first successful climate necessity defense case was actually done in England. It was the King's North 6. You had Greenpeace activists who climbed a tower of a generating plant, basically, and climbed the chimney stack and painted on the chimney stack, and it shut the plant down for a few days. And they claimed, yes, we know we have interrupted the power supply here, but we did it because we're burning down the earth. We have to stop this. And they were successful. They were acquitted on all charges. And so I don't know, because I haven't studied enough, whether that inspired U.S. climate change activists expressly, but shortly after that, the next year in 2000, just shortly after that, you had the first U.S. climate necessity defense case, and of course that was, as many of you know, Marlow will know, Tim DeChristopher, who was bidder 70, illegally bid on BLM oil gas leases in southern Utah, and that was the first time a necessity defense was used. He used the necessity defense there. It was not allowed, and he spent almost 2 years in jail for that. So this marks, actually, that was what, December 11th, 2008. So this is the first time we've met in 10 years since that. And his trial was actually in 2009. So we are at the 10-year anniversary. So this is really an amazingly recent phenomenon. This is not something that's been going on for centuries, not even decades, barely a decade. And that's why it's really important to talk about it now. Initially, there were a lot of hard times. And things maybe are changing. That's what we're going to talk about. The next, and there are other cases, but these are just some highlights. The next big one that we want to talk about was in 2012, the Michigan Coalition Against Tar Sands, the MCATs, who shut down some oil and coal trains up in Michigan. They posited the necessity defense. It was denied. They had certain, I can't remember what the charges were, but had kind of reduced charges brought against them. Oh, sorry, is that better? Keep that mic up, Professor Long. Okay, thank you. That's one of my students. I usually don't teach in such big rooms, so I just scream and yell and everyone can hear me. Then in 2013, we had the lobster boat blockade, the lobster boat blockade with Ken Ward and Jay O'Hara. And of course, that was a wonderful, high-profile case where Ken and Jay bought this little lobster boat and blocked the entrance to the port for a big coal ship coming in. And of course, they posited the necessity defense. It was denied, or actually denied, or not even allowed, or maybe allowed, but it never happened because the prosecutor dropped the case on an amazing, the day before trial, made the big public announcement and said, I think Jay and Ken are doing the right thing. I'm not going to bring this claim against them. After that, we have a few other ones. There were other ones against the Keystone XL pipeline. Alec Johnston did that one. We had the Flood Wall Street. How many here were at Flood Wall Street? Yeah, there's a few of us that were here. Oh, there they are, Deb and Pat in the back, yeah. That were there. Were you guys arrested there? No, okay, none of us here were arrested at Flood Wall Street. But anyway, in that action, the dozens that were arrested actually posited the necessity defense. And all of these defendants basically are saying, we trespassed, we shut down a pipeline, we blockaded a railroad, an oil or coal train railroad track. We did these things, but it's because there's a much greater harm here. And the Flood Wall Street defendants were denied a necessity defense claim. And although they were given, I think, nominal sentences just because there had been some due process, some constitutional violations in the way they were arrested and handled. So that was kind of fun. And then there's the Delta 5 in Washington. These 5 activists hung themselves from a tripod on an oil coal train track coming out of a plant. And they actually, initially, the judge said, he was going to let them. First, he denied their right to have a climate change defense. Then he allowed it. And then, after they put on a climate necessity defense, he actually said, no, I'm not going to let the jury consider it, and threw it out. And they were, I think, acquitted on one charge and charged with one, but it was a reduced thing. Finally, a couple others here to bring us to the present one. I think one of the most important is the valve turners, the shut it down case. And Emily will talk much more about this, where we had 5 activists in Washington, Minnesota, North Dakota, and Montana simultaneously shut down coal tar sands pipelines coming from Canada to the U.S. all were arrested, and all had. As one who's chronicled this about this, amazing results to the various trials. They stem from Michael Foster in North Dakota being denied a defense and spending almost, 6 months in jail, to Leonard Higgins here, who actually was, again, had a judge that it was more cavalier than most, denied the necessity defense. It was probably the most thoughtless denial of a necessity defense that I've read, and just basically treated it as it was the most ridiculous thing. You're just trying to get media attention for something that doesn't exist, and stop trying to turn my courtroom into a media political circus, and denied it. Although Leonard was convicted, but spent no jail time and had to pay several $1,000s in fees, right? And then we come to, of course, Emily's, and this is kind of where I'll end this here, who had the case that looked like it was going to be the final, the first time we actually got a judge to listen to a climate necessity defense, allow a jury to hear it, and it looked like, it was going to go really well for us, until at the eve of trial again. What happened, Emily? Okay, I'm not going to spoil it then. I'm not going to tell you. But Emily is probably the most amazing case, and how hers went up to the Supreme Court and back and everything, but she'll talk about that. And then there's been the Reverend George Taylor, who had blocked a train in 2017. There's the Roxbury 13 that have been talked about that did an action up in Boston. All of these people, none of them have ever been able to yet successfully put on a complete climate necessity defense. We've come so close in so many cases, and we're going to talk about how the cases are going now, what's happening. But that gives you kind of a brief history of the climate necessity defense and the necessity defense in general since 1550, kind of to where we are today. So with that, I will turn it back over to Alice, and we will continue on.
Thank you, Lance. Yeah. So I think that was a good introduction. We're going to see if Marlow, who's on the projector, can be heard by everyone. And if so, we'll have her fill in and provide a few extra details in some of those cases that she was instrumental in putting on. Marlow, do you want to try to chime in here?
Yeah, can you all hear me?
Yay! Yes, we can. Success.
All right, great. Thank you for that exhaustive list that I have a few things to add to, which is exciting, that the list keeps growing. I think the first thing I wanted to say is about the lobster boat trial. The judge had allowed a necessity defense, and we were ready to go, and it was actually the day of trial, right before jury selection, that the district attorney walked in, and he was actually carrying a copy of the Bill McKibben Rolling Stone article that called us all to come to the People's Climate March that fall. And he dropped the charges, and then he asked if he could come to our press conference afterwards. And when he finally came outside, he told the crowd just what you heard, that he thought that climate change was the gravest moral crisis humanity had ever faced. And he actually announced right then that he was going to march with us in the People's Climate March in 2 weeks. And we didn't believe it. And he did. He brought his whole family and his staff, which was kind of amazing, and marched with us. I wanted to say that with the Delta 5 trial in Everett, Washington, they went to trial in January of 2015, I think it was. Yeah. They actually, I wasn't sure, I didn't hear this part, but they were allowed the necessity defense and were allowed to present all of their witnesses. And Emily knows a lot about this trial as well. And the judge decided not to give the jury instruction, but 3 of the 6 jurors came out afterwards, and there was hugging and crying, and signing up to go lobby against oil trains. And they stayed for sentencing. We had sentencing that day. They also told us, this is interesting, that they had gone into the jury room determined to figure out how to acquit. And of course, like most jurors, they were under the impression that if they brought a verdict that was contradictory to really clear evidence, that they were going to have to justify it to the judge. And so they only found a way to acquit on one charge, and they convicted on trespassing. Yeah, and on the West Roxbury case, I'll be ready to talk about that later.
Yeah, I think
we did get a ruling from a judge. It was just on a civil infraction.
If you want to summarize the West Roxbury case now, I think that would be fine, actually. We'll be talking about cases where there were charges that were either reduced or dropped altogether, and that case is a really good example of it.
Great. So that case involved, it was a sustained campaign of resistance that lasted over a year. More than 200 people, or about 200 people, had been arrested. And there were 13 people still hanging in, headed to trial from, it was either 4 or 5 different action dates. The judge had combined them. And their charges were already pretty low. They were misdemeanor trespassing and disturbing the peace. And the judge had been very clear. We'd been in court, we'd been in discovery for like 12 months because of some holdout from the company to provide documentation that the judge had ordered. And when they finally admitted that they had no safety plan, which they had been telling the city that they had for 2 years, then we were ready to go to court. And the judge had been telegraphing that she would allow a necessity defense, and she said that she would decide the morning of that the jury trial was to begin. And after the prosecution received our witness list about a week before trial, they decided to drop the charges, and we were given the option of that or of a civil infraction, like a parking ticket. And I was the person who had been organizing between the defendants and the lawyers, and also all of the support people. And we'd been doing this for a long time, and people had been working toward this trial. And so I said, let's not end it so anticlimactically. Let's have our one day in court. And then when we got to court, the defendants asked the judge if each of them could speak for 2 minutes about why they did what they did. And she said yes. And then Tim DeChristopher and one other defendant both asked the judge to rule, to find them not responsible by reason of necessity. And she did. So no precedential value, but a judge that had really been in the case for a long time seemed like it was very clear to her.
Thank you, Marlow. So just to kind of paint some broad trends in terms of what's happening. Okay, I'll do my best. So there have been about 21 cases overall in which climate activists have tried to argue necessity. If you want a complete list of those cases and a short description of them, there's a document on my organization's website on our resources page. So if you go to Climate Defense Project and look on our resources, it's called Necessity Defense Case Guide. But just to sort of summarize some larger trends in terms of the cases that we're hearing being summarized, most of the cases in which climate activists were going to a jury trial and were intending to put on necessity evidence, and about 11 out of all of those 21 cases, the necessity defense has been denied prior to trial. So that is sort of the most common outcome so far. But there have also been a number of cases, particularly cases that were to go to a jury, where the prosecutor has either reduced the charges or dropped them altogether prior to the trial beginning. And those cases have become more frequent over the last couple of years. So that's a trend that we're going to be talking about and trying to analyze a bit. There's also sort of a separate category of cases that have just been bench trials. That, in other words, where only a judge is presiding over the proceedings. And just for a very brief background, whether or not you get a jury in most states depends on sort of the length of the potential sentence associated with your charges, right? And so that's it's actually a lever that prosecutors have if they want to sort of deprive these defendants of a jury and deprive them of that platform. They can reduce the charges and often just have it converted to a bench trial. But we've seen quite a few bench trials as well, and there's actually been a little bit of a difference between the bench trials and the jury trials. We see judges being more willing to allow necessity evidence at bench trials. And so we're going to be talking about that as well and why that might be. And then I think the only other category would be bench trials in which necessity wasn't allowed at all. There aren't as many of those, but again, if you want sort of a complete breakdown and to see the numbers, look at that document on our website which lists all of these cases. So I think since we're running a bit behind, we'll skip right to sort of analyzing like what's going on, and I want to start by getting the other panelists' opinion on what they think might explain, first of all, this unwillingness of judges to allow necessity, particularly in jury trials, but also this weird trend we're seeing with prosecutors either dropping or downgrading the charges, because I think those are both really interesting and worth getting different perspectives on. So does one of you want to start out? Yeah, Emily.
Yeah, so the thing that happened, is this good? The thing that happened in our trial that was so strange was that the judge granted us the necessity defense, had our expert witness list, a version of it, for almost a full year before trial, because then it was appealed. The appeals court for the state of Minnesota upheld the granting of the necessity defense 2-1. And then it was appealed to the state Supreme Court, and the state Supreme Court refused to hear it. So it was, that had several precedents in there, because there had never before been a written granting of necessity defense. Then it was upheld at both the appeals court and the state Supreme Court. But what happened was 4 days before trial, the judge, in response to some motions, some very standard motions by the prosecution, who basically had asked that we be allowed fewer witnesses, all of a sudden the judge turned that around and said, well, you know what? They're not going to be able to have any witnesses speak about climate, speak about lack of legal alternatives, or speak about the uses of civil disobedience. And the thing that made this so absurd, he actually even quoted the dissenting opinion of the appeals court that upheld his opinion. So it really made no sense at all. And what it left us with was a gutted trial, because, I'm a poet, Annette is a retired lawyer, nobody's going to listen to us about the imminence of climate change, as opposed to Jim Hansen, who was present and was going to be one of our witnesses, or Bill McKibben, or any number of other folks. And so, but one of the things that was also happening simultaneously, of course, is the court of public opinion. And one of the things happening in the court of public opinion in the months leading up to trial was all kinds of op-eds and letters to the editors basically saying, this will unleash chaos. If people are allowed to put on this necessity defense, it's going to be crazy. And what's so interesting about that to me is that in the earlier cases, in Ken's case, for example, which was the first Valve Turner case to go to trial, when it was turned down, it was basically turned down on the basis of two things, kind of imminent. I mean, climate change may be real, but is it imminent? And then even if it is real, and even if it is imminent, how on earth is your turning off that pipeline going to do a damn thing about climate change? And so, and we had answers for all these questions, of course, but all of a sudden, it's kind of like climate change more broadly in the narrative, right? It goes from people thinking oh, not a big deal, we don't have to worry about it yet, whatever, that thing over there, to all of a sudden, oh, it's too late, and that's very handy, because there's no space in there for accountability or action, right? And so that seems to me largely like what's happening from the prosecutors and judges in a sense as well, because it goes from climate change isn't real and this is just dumb to if people start saying in court that this was necessary, it's going to resonate with people so strongly that it will unleash chaos, because I mean, like, why would it unleash chaos if people didn't believe it? People in the jury, people in the community, and so on and so forth. Nothing's going to change in that community unless they believe us. And that's what they're afraid of, is they're afraid of those expert witnesses and the way in which people will respond to those expert witnesses. You bring that into trial. And I was at the Delta 5 trial. And it was really interesting to watch day to day. I mean, the judge was visibly shaken. All the members of the jury were visibly shaken by the testimony of the expert witnesses, because the stuff that they were saying was stuff that if you read the news and you kind of believe in climate change, or you think it's probably real, but you're not paying the kind of attention that a lot of the folks in this room are paying, that the information being spoken by those expert witnesses was freaking people out. And obviously that's what we need. That's what we're trying to accomplish here, is for people to have that visceral understanding of what's going on. And it's clearly happening, and judges and prosecutors are afraid of it happening, flat out. So.
Yeah, Emily, I hit the nail on the head. Those are two big reasons, the imminence prong, as well as, oh yeah, your little protest is going to stop climate change. Those are two big things. And she's right, though, when she says they're afraid. They are, because Ted and I, during our research, when a necessity defense goes to a jury, almost, we'd say 90-some% of the time, the jury is going to listen to a legitimate necessity defense. Juries can spot BS necessity defenses just fine. But a legitimate necessity defense, juries understand it, and they rule in favor. And that scares judges who view the judicial process as their private domain. Necessity defense brings in democracy and the good sense of people into our judicial process. It is essential to a democratic system. It seems funny that on the one hand we have, respect for rule of law, and that's what we do in democratic societies, but I would say it's just as essential to have disrespect for the rule of law when it causes harm. One other thing that judges use to deny necessity defense, having a necessity defense go to the jury, is the legal alternatives prong. We see that a lot in these cases, that the judges say, you could have just asked Congress to pass a law. It's that easy. Why don't you just go lobby someone at the EPA? Of course, the Trump administration has made that argument much easier for climate change activists, since they've shut down every possible legal alternative. So that has been helpful, although it's been a disaster for our environment. But so that's been a big problem. And the reason that's a misunderstanding is you have to have reasonable legal alternatives. They have to be honestly available. And in many of these cases, especially in some of the valve turner cases, they've actually gone through and dotted their I's and crossed their T's, and they've tried to do it legitimately. They've tried legal protests. They've tried the media route. They've tried to lobby their senators, their representatives. They've tried to pass legislation. They've done literally almost everything that's reasonably available. And judges don't understand that. Judges seem to think that as long as they're a theoretical legal alternative, that's okay. But that is not what actually the necessity defense in the cases decided under necessity defense actually requires.
Great, thank you. Marlow, I want to give you a chance to weigh in on this if you have anything you'd like to say.
I wanted to just echo Emily about at the Delta 5 trial, and even a little bit at Ken Ward's first trial, when Ken was allowed to present a little bit of scientific evidence to speak to his state of mind, even though he wasn't granted a necessity defense. But in both of those settings, the prosecutor, I think, was the one person Emily didn't name that was freaked out. And in the Delta 5 trial, we kept noticing that while the climate expert witnesses were testifying, it seemed that maybe he was hearing things he'd never heard before, and his one of his legs kept really, like his knee was really bouncing, and then he would notice it and stop it, and then it would start again. So it feels like a particularly important opportunity to be able to bring that into the system. I wanted to also just underscore the part about both reasonable legal alternatives and the idea that you could be effective. We were really excited in West Roxbury to have a chance to bring a necessity defense case, which in the end, we didn't get to bring one to a jury because we had people who were part of a sustained campaign of resistance who had shut down work on different days. And so already within our defendant group, we had people who could say, well, I knew this wasn't just happening in the one day. Like, these people did it before me, and these people were coming after me. And there were 36 action days total. And so I think one of the biggest challenges, or the thing that, as far as I can tell, we haven't done as well as we might yet, is really make that argument. We haven't had very many chances, but make that argument about what social movements do and how actions can spark other things. And then in terms of the reasonable legal alternatives, I think we ought to be able to make this case pretty well because of that standard of reasonability. It, particularly if we're talking about interstate pipelines or anything else that is regulated by FERC, we understand that to be a rubber stamp system that is set up for us to give all the input and feedback that we want, and for those pipelines to be pushed through. And so I think there's ample evidence of that, and it's just getting a judge to allow us to bring it, I think.
Great, thanks, Marla. Just a few more thoughts here to sort of offer more potential reasons that we might be encountering these challenges or ways of interpreting what we've encountered. So one thing that I've noticed is that judges are kind of saying one thing and doing another in a lot of these cases. They've been pretty adamant about denying necessity defenses, not sort of getting that formal legal recognition that everyone has been looking for. But on the other hand, a lot of the actual sentences or punishment in these cases has been pretty low. You know, we were talking about the Tim DeChristopher case. Of course, that's the outlier. He spent nearly 2 years in prison, but that was also 10 years ago. And since then, I'd say the worst consequence that anyone has had was in the Michael Foster case, where he served 6 months in jail. There's also been like a restitution award here or there that's been a little high. But especially in some recent cases, some of these bench trials, for instance, we've had really favorable opinions from the judges in which they said, I'm not going to recognize necessity, but I also want to applaud these activists for what they've done. I think it's really admirable, and I'm not going to give them what the prosecutor's asking for, or I'm not going to give them the maximum punishment under the statutes. And we've seen juries do that as well in cases where there's been jury sentencing. So I think that's a worthwhile trend to notice, right, is that even though you don't have the legal recognition, people are really sort of sympathetic oftentimes in these cases. Another trend I want to just mention is this trend of prosecutors not following through in so many cases, right? And I think there are many potential reasons for that, some of which are less interesting than others. In some cases, like in Emily's case, the statute just isn't a great fit. The prosecutor had dropped so many charges prior to that trial happening that there was one charge remaining, and he just couldn't put on the proof to actually, to make his case adequately, and so the judge dismissed it. But I think, it could also just be a resources issue. A lot of these, state DAs, offices don't have a ton of resources, and they're not used to taking, especially cases like this, all the way to trial. And then it may also be a reflection of sort of political will. This has happened twice now in Massachusetts, where a DA's office has decided, we're just not going to spend our political capital here. Like, we're not going to prosecute these activists. Another theory is just that there's kind of a sparse record of successful necessity defenses in the case law. And there are different reasons for this. It's kind of just one of those accidents. But one reason is that state trial courts often don't issue written opinions. And most of these cases have been in state court. And so you don't get much of a record that way. And another reason is that when you have a successful necessity defense that results in an acquittal, as they frequently do, which Lance said, that's not something that the prosecutor can appeal. So again, it doesn't go to that next level where you get a written opinion that would show up when people are doing research in the case law. And then I think, I just want to, again, go back to that difference that we're seeing between jury trials and bench trials, where judges are much more willing to allow necessity evidence in bench trials. And I think, this goes back to sort of this fear that Lance was alluding to of judges turning their courtroom into a circus, or this fear that a lot of judges have of sort of instrumentalizing their courtroom for a purpose that isn't quite proper. I think also, there's just a lot of really conservative interpretations of the rules of evidence. Courts tend to be very careful about what evidence they'll let juries hear so as not to confuse them. So there's a little bit of almost like paternalism as it relates to jurors and juries, I think, that's going on. Again, that may not be like an ultimate explanation, but it's worth noticing. And then the last theory, which this is actually something that one of our expert witnesses in the Minnesota case mentioned. He's a pipeline safety expert, and he seemed to be of the opinion that if the state had really made its case vigorously in that trial, they would have had to get into some fairly technical subjects. They would have had to talk about the safety of how the pipeline was being operated. And doing that would have kind of opened the door to our evidence sort of rebutting all of that and saying, actually, what these activists did was much safer than sort of the pipeline's everyday operations, right? And so his theory was that they just didn't want to get into that at all. So I think now we'll transition into our discussion of, given this landscape, given that it's been fairly hard to get actual legal recognition, is there nonetheless value in continuing to make these arguments? Even if we know that the chances are very low of getting an actual instruction, having a jury decide on that basis, should we still be doing this from a climate movement perspective? So again, I'll start with everyone else's input, and then we can go from there. Does one of you want to?
Is it worth it? And of course we're going to say, no, stop, yes. And I want to bring in a perspective that I don't know if Alice or Emily or Marlow is thinking about this, but let's just set the disasters of climate change aside for just a second. If there's anything we learned from going to this conference, it's that climate change is so serious and so important that if we do nothing but address that, we're still addressing the most serious and important thing in our lives right now. But let's set that aside if possible. Let's think about what this does to our democracy. Ted Hamilton and I make the argument in our article that basically what's happening here is that we are being denied Sixth Amendment rights. There's very firm rights to present a full defense under the Sixth Amendment. You're entitled as a criminal defendant to present a full defense. The denial of necessity defense basically denies the defendant the opportunity to present their defense. They've broken a law and in most cases freely admit that they've broken a law. Their case rests solely on a defense. If that defense never goes to the jury, they are really narrowly defining and virtually eliminating Sixth Amendment rights for criminal defendants. And it's a serious problem. If people generally understood that and understood the democratic underpinnings of the necessity defense and the Sixth Amendment underpinnings, I think they would be much less likely to buy into the rhetoric that Alice was talking about of the judges are the experts, that paternalistic idea that they need to control their courtroom, they know what's best, they are trained in the law. So I just wanted to throw that out there as apart from climate change reasons that I'm sure that my other panelists here will discuss, that's an important rule a reason to go forward for our democracy. I really feel strongly that if we don't continue asserting the necessity defense in one of the most important issues that we can assert it with today, that we are giving up really important rights under our democratic system.
Yeah, I agree with that 100%. The other thing I think is important is, so I think trying for the necessity defense in civil disobedience acts across the board is useful because it gets people talking about it, it gets people thinking about it. You can maybe actually get it in one form or another, or even the full form. Somebody will eventually get it in the full form. But the place where I think it really makes a difference is if somebody or somebody's are willing to engage in high legal risk actions, because that really, one of the things Tim Christopher has talked about a lot in terms of civil disobedience is its value is not just in, and not even, I would say, primarily in what happens in the law. The value is that when you make yourself vulnerable in the way that taking a major risk of going to prison for a substantial period of time does, people respond to what you're saying very differently. It resonates very differently. I am the exact same person I was before this action, and I get asked to speak, and people listen to me very differently as a result of having done the valve turning action. And there's part of me that thinks that's silly, but I also understand that there's a way in which all of us are responding to things both rationally and emotionally, right? And so to know that somebody was willing to do that, it does, sort of makes people less likely to be dismissive of you and say, oh, talk is easy or whatever. And, to be honest, the scariest moment for me personally, after the action, in terms of legal risk, right after the action, we didn't actually have lawyers on the ground. That was, Michael had 81 years worth of charges. So that was, we had a pretty tense couple of weeks when we were figuring out, who was going to represent us and what that was going to look like. But then, everything sort of started on its, very slow grinding wheels of justice way. And, and it just started moving forward. Everybody got out of that state of, nervousness, because you can't really sustain it for that long. It just sort of becomes part of your life. But then in October 2017, so also to be clear, one thing that we did not bank on in any way, shape, or form when we did this action was the election of Trump. We never discussed that. It never crossed our minds that might happen. And so we thought we were dealing with rational actors at the federal level. And we knew we were risking federal charges. In fact, in at least Ken's case, Ken was really hoping for federal charges because that would really raise, the profile level of what was getting talked about. But federal charges facing just Sessions, no, that is not something that we were seeking or even imagining. And in October 2017, 83 U.S. reps sent a letter to Sessions saying, why are these people not being prosecuted as terrorists? And don't you think you have the tools? If you don't think you have the tools, basically get the tools. We'll give you the tools. And it wasn't just our action, but our action was specifically called out, one of two or three. And so for a week not a week, that's a lie. Maybe for 2 days at that point until we got fuller briefings from the lawyers, it looked really likely that the, feds were going to show up at our door and we were just going to be disappeared into the prison system, until further notice, essentially. And, honestly, in terms of the impacts of the action, that would have been the best thing that could have happened to us. You can't engage in these high risk or in any civil disobedience actions without understanding that part of the value is if you are sacrificed in some way, and so you have to be at a point in your life to be where you can do that. You have to have a fair amount of freedom and privilege in your life for that not to be something that's really terrifying. But you also have to know that in order to make a difference, you're going to have to go to prison probably, and maybe for a substantial period of time. And that, again, having a federal trial about something like that, especially under an administration like the Trump administration, that would have been an incredibly important trial. And so again, you have to understand that to some degree, the risks you're taking are commensurate with the impact you can have, flat out.
Great, thanks, Emily. Marla, do you have anything you'd like to say about the value of continuing to make these arguments?
Yeah, thank you. And if I repeat anything Emily said, I'm sorry. I was only getting maybe half, like able to hear about half of what she said. So I think that, I guess, I'm sure Emily talked about sort of the organizing value of having, of keeping the action alive. One of the ways that that I sometimes talk about it is if people are willing to try to have a necessity defense trial, we like to think of it as taking your action through to trial. So not imagining that your action ends when you're arrested, but that you could use the entire trajectory of that journey to build power. And that could look like a lot of different things, but of course, that only really works if you've got a good, like a pretty good sized team of people, because it's a long process and it's exhausting, and people willing and able to learn how to tell the story and keep pushing it out there, how to organize people to continue to show up and support, but also to use the story of what happened in order to help keep encouraging other people to withdraw their own consent in whatever ways they feel called. So sometimes that looks like somebody does a big action, like a valve turning action, and that could be a signal. The lobster boat action ended up being like a signal action where a bunch of people, we thought this might happen, a bunch of people in the area in Massachusetts afterwards were like, I didn't know about this. I would have done it. I want to do something. And conveniently enough, the 350.org summer heat actions were coming a few months later. And we said, good, because we've already planned to have a summer heat action at Brayton Point. And so 400 people then showed up there in the wake of that. And they wouldn't have gone to Brayton Point where the lobster boat action happened because there hadn't, they needed a signal that like, it's okay to have moral imagination, that we could shut this place down, because that wasn't a place that people really felt like there was any possibility of shutting down. And there were a lot of serendipitous things that were happening right around the time of that action that we didn't have any control over, but that plant was for sale, and but nobody wanted to buy it. Because it wasn't profitable, but the company selling it was bundling it with 2 profitable coal plants in Illinois. So we knew that it was probably pretty likely to be shut down by the people who bought it unwillingly. But we also felt that extra public pressure and dissent could hasten that process. And that plant was shuttered in, I think it was 2017 in May, which is great. In April of this year, they're going to implode the cooling towers, and we're probably going to have a dance party. I think it's April 27th. April 27th, Somerset, Massachusetts. Join us. The other thing I wanted to highlight is I did hear that part about Emily saying that, bringing the point about a big part of our power in this situation is the vulnerability that we've chosen to take on and to live into, and that it might be most powerful when some of us are sacrificed. And I just wanted to back that up by saying, yes, but only really if you've got a team around you who's prepared to keep telling that story. So I guess for movement building value, so it's one of the things I do a lot is help people prepare for trial and how to organize for trial to get their people there and out and build those teams. And it's really exhausting, and it's really important to have a team of people who can keep telling the story, even if you have to go away for a while and you can't tell it as well yourself for a while.
Thanks, Marla. I think we've got a few minutes, about 5 more minutes until we'll stop and take questions. So just to sort of wrap up this discussion of what the value is of continuing to bring these defenses, I actually just want to start out by mentioning a few instances in which maybe it doesn't make sense to bring a necessity defense. That hasn't changed, in the last several years, but it's always been sort of a bad idea to bring these cases when you're appealing, for instance, like a negative ruling, and you're in a state where the law on necessity is really bad, and so there's a good chance that you'll set a bad precedent. Again, like people can have different opinions on that, but that's something to at least think about, right? Also, if you have defendants who, you don't want to force this on anyone. If people aren't comfortable with taking on that legal risk and going to trial and not just pleading out, that's something that needs to be really seriously discussed. As Emily was alluding to, this is something that requires a fair amount of privilege, and obviously it's not everyone's first choice. And then finally, some attorneys just aren't entirely familiar with putting on a political trial. They may not be especially warm to the idea of arguing necessity, or might just be in this sort of mindset that you should always reduce people's potential legal consequences as much as possible. So again, you need the right attorney. But I think those are fairly discrete circumstances, and sort of the larger value of these arguments continues to remain true, as everyone is saying. And so I just want to add a few more points to these really good points that everyone has already made. For me, sort of one of the first things that I think about in terms of the continuing value of these arguments is, if judges really are going to keep on denying them, keep forcing them to do that. Keep up the pressure on them, right? Because climate change is only getting worse, and there's only more and more climate protest right now. And so let's make them continue to justify these decisions, right, in the midst of climate catastrophe. And let's keep highlighting the disparity between what they're saying in their written opinions and what they're doing when it comes to the punishment and the sentencing. And the other thing, just again, going off of my earlier point about prosecutors dropping and downgrading these charges, keep calling their bluff. They're going to bring these charges with 81 years, in prison as like the potential high sentencing amount. Keep forcing them to try these cases and prove it to a jury. And we might find that, as we've seen more and more often in the last year or two, a lot of these cases will not actually happen because prosecutors either don't have the resources or the political will to go through with these cases. Another thing I want to just mention, and this came up a bit when Marlow was talking about the West Roxbury case, Massachusetts v. Gore. So one really nice thing that the court process can provide, and is a little bit unique in this way, is that it can be a sort of a forum, and it provides a process for fact-finding, right? So Marlow was alluding to the discovery process in that case, in which they had tried to get the company to produce a safety plan to back up what it was saying. And it turned out, late in the game, that the company just did not have that, right? And that's something that, courts, it's nice to be able to compel someone to produce something, right? And so that's totally, in contrast to sort of the era of fake news, that we live in. Like, that's a useful thing that the legal process can still provide. And then finally, to just echo what Lance was saying about the democratic value of these kinds of arguments and trials, I think that's really worth underscoring, right? I think these trials have the potential to be good for all of us, particularly in this era where people feel really shut out of democratic institutions, right? There's not a lot of access to elected representatives or even regulatory bodies. People really need to feel empowered to participate in community decision-making, because ultimately this is something that impacts communities first and foremost, when people are building pipelines, when there are coal trains going through communities. And so when you have juries, a jury of a defendant's peers sitting in judgment, deciding should this person be held legally culpable for this, this action that they did, I think that's really powerful and engages people in a much more meaningful way than just, hearing talking points on CNN. So I think with that, we will open it up to questions. Again, we have just about 5 minutes, maybe a little more. And do we have a runner for the microphone? Thank you so much.
Yes. Okay. I have no understanding of law, so I'll start with that. So my questions might be crazy. So one question is, when the necessity defense is actually presented, when you are allowed to do that, can examples of success be presented at that time, like how to combat the issue? Can that be done at the time of a necessity defense? The other question is, again, here's my lack of law understanding coming through. Can there be some lawsuit about the lack of about the problem with the Sixth Amendment rights being denied?
It's a great question, and the answer is absolutely yes. And Emily was just nodding her head because the direct causality, the reasonable expectation of direct causality requires you to go and show other instances when the necessity defense has been successful. So the jury hears this. You get to bring into evidence, this is why I had a reasonable expectation, because in this case, in this case, in this case, in this case, it did make a difference. And so it does provide that. And then as to the second one, can you bring an actual claim for violation of your Sixth Amendment? Yes, you can. No one has, as far as I know, brought that up in a climate necessity defense case. It would be something that would be more likely brought up on appeal. And this is kind of a very new thing, this whole idea within climate change defense. And like I said, that's what Ted Hamilton and I write up a lot about in our article, that this is something we really need to look at and a basis for argument at trial, and maybe even more importantly, as a basis for an appeal.
Yeah, the Sixth Amendment argument is one that we at Climate Defense Project routinely make both at the trial stage and at the appeal stage, sort of prospectively saying you should grant us this because otherwise it would deny the right to a complete defense, and then later after they've denied it, we make it again.
So I guess I'm following up to the power of the jury in terms of democracy, and I wanted you guys to comment on how you feel about the voir dire process, if you feel that that strengthens the democracy or if it takes away from it, and kind of in the whole context of the rules of evidence and the management of the court process by the judge.
I'll give you my thought on it. Of course, you have to remember, voir dire depends. These are generally state court actions. And so the laws and the jury selection process varies in every state. My personal feeling is that it actually, anytime you can actually bring up these issues and talk about these issues, even if voir dire is used, and we know it is used, to exclude jurors who are favorable to your position, I think it's a net benefit. Even if it has the effect of excluding some people, just by seeing what questions are asked and how that process goes, I think anytime you can get this out in the public, it's a benefit. Even though it can be used, and powerful, corporations and plaintiffs in these actions, they have a lot of money to do a lot of background research and on potential jurors, and do things that maybe the defendants don't have as much ability to do it. So maybe that skews the playing field a little bit, but I still view it as a positive, that whole selection process, as being something that brings issues out in the public. And if they're asking certain questions, why would they ask those questions? So that's my take on it.
I'd also add, Leonard, you were obviously at the same trials I was at, but, one of the most heartening things to me was even in the most conservative jurisdictions where people clearly weren't at all sure about climate change, people take very seriously the civic responsibility to show up as jurors and assess the information, and watching people metabolize that, because there's something we all kind of know about, people probably, heard about it sometime in I don't know, junior high or something. They have a vague idea what it means to be a juror, but you get them in there actually physically in the courtroom with, in the voir dire process, spoken to by the lawyers. And I felt like I could visibly see people struggle with these questions. And that was really heartening to me, to watch people try to understand what their civic responsibility was so that they could rise to the occasion, and that is something that, that if it sticks at all is good for every aspect of a democracy, right?
Marlow, is there anything you wanted to add to that?
I just wanted to say that I recognize Leonard's voice and I wanted to say hello.
Yeah, I mean, I think just sort of thinking back to Emily's trial and the voir dire process there, although it was disheartening to see how many people sort of dodged the question and just sort of said, well, I don't really believe in climate science. I don't think the defendants, had to do what they did. It wasn't safe, et cetera. There were one or two jurors in that pool who were clearly going to get knocked off no matter what, so they just used the opportunity to sort of make a statement. And one of them was a local farmer who, just spoke very plainly and I think compellingly about his belief that we're on the wrong track and climate change is real and people should believe in science. We believe in science when we take our kids to the doctor, but why don't we believe in it when it comes to climate change, right? And so I think that was more powerful than anything we did in that courtroom, was just hearing that local farmer talk about that.
I was just following up on this woman's question, and I'm also legally ignorant. So I believe the question is, when you get a chance to present your necessity defense, can you also present solutions to mitigate climate change?
I think that topic does come up sort of obliquely in the sense that we're talking about lawful alternatives, as the others were mentioning. That's a prong of the defense. So we'll often talk about other things that the political process is failing to do, that it should be doing at this moment to address climate change. It also sort of, we get at it when we talk about the effectiveness of civil disobedience, right, and opening up political space for major political developments or major court decisions. So those are the two main ways that I can think about it coming up in this context, is not, the lawful alternatives prong and then showing why civil disobedience works. Is there anything that,
Well, just really briefly, the other thing is in terms of the efficacy of the action, the thing we have to do to mitigate climate change is to stop using fossil fuels, right? And stop transporting them and extracting them and so forth. So in a way, you are speaking to your own mitigation of the problem when you say we have to shut these pipelines down now.
Yeah, and I think that maybe implicates the imminence prong as well, that you have to be able to talk about why we have not been able to do anything legally at this point, and the imminence of this justifies that nothing we can do short of radical action will actually deal with the reality of the climate catastrophe.
okay, I think we'll wrap up. Thank you, everyone. We'll stick around if anyone else has questions.